Hi, everybody. Just getting set up here. Good to see you all. It's been a while since I've gone live. Just as a reminder, I am live on both TikTok and YouTube. Hello, YouTube. Hello, TikTok. And let me just get my chat up so I can see any questions anybody has. So if you have never been to one of my lives before, I am here to answer any questions that you have about basically things that are going wrong at work. Hey, TikTok watch. Yeah, it has been a long time. I've been so busy that I was like, hey, let's go say hi to people. So if you have any questions about things that have gone wrong at work, issues that you are having in the tribunal process, or if you just want to understand how the employment tribunal process works, then I am here to do what I can to help. Bex says, hi, your website has been an incredible help for me. Oh, I'm so pleased to hear that, Bex. That is really good to hear. Have you used the free platform, or is it the website guides? What's helpful? Because then we'll try and do more of it. So I'm live on both YouTube and TikTok. TikTok watch. Okay, I'll come back to you. And just a quick reminder. So for those of you who don't know me, I am not a lawyer. I am a technologist. And I got really pissed off about the fact that so many people were so not able to fight back at work, and started looking into that as why can't people seem to be able to do that? And that's why Vala exists now. We have built a platform that allows people to manage their own legal case, basically, all the way from before it gets legal, like a grievance, all the way through. If you have to go the whole shebang, we can support you through the whole shebang. Oh goodness, look at all these. Oh, hello. So speaking of supporting you through the whole shebang, TikTok Watch says that their final hearing is set for 2025. That is wild. Yeah, that's the kind of timelines we're seeing at the moment. And it's so frustrating. Like, you just have to wait for so long. I'm really hoping that I know that they're doing more to try and get the backlog dealt with, but it's such a big backlog at the moment. And I mean, the good thing is it does give you time. If you are trying to reach a settlement with your employer, it does give you time to negotiate that and to kind of turn the screws a little bit. But yeah. Oh, hi. We met at the Legal Tech thing at the Law Society with Shirley. Love your videos. Hi. That's so good to see you. Hello. A few more comments here. So Bex used the case management service and it was amazing, so helpful. I'm so pleased to hear that, Bex. Thank you so much. Happy Monday to you as well. LeBloom said, I paid for a 2-hour session and it was so helpful, gave me confidence. That's the goal. We have lawyers, but it's so expensive to have a lawyer represent you. So we thought, well, why don't we just get a lawyer to coach you through managing it yourself, so that you get their legal advice, you get their opinion, but then you can keep the costs really low by just running the rest of it yourself, but with their input and often their injection of confidence, which is often what's really needed. Okay, so we have a question on YouTube. Hey, lovely. I had the first 4 days of a part heard final hearing in April. I have another 4 days in September. Woo! Goodness gracious, well done. If there's any new evidence for the case, how do I add that into the case or bundle? Good question, Sir. So, Sergio, I wonder, the short version is I don't know for sure. One of our coaches would know, but I don't know because I'm not a litigator. However, I would guess that you would be contacting the tribunal to ask if you could amend the bundle. But I don't entirely know. I think we'd need to ask a coach. You need to ask a coach for that one, I'm afraid. I don't know. Are you working with one of our coaches? Right, let me go back whilst you answer that and see if I can get a few more. Okay. I've referred my friend to your website. She was told that talking about the CEO's salary is a GDPR breach. GDPR is personally identifiable information being breached. I'm not sure. Do I simply send it to the tribunal or build another bundle? This is the question that I don't know the answer to, and I'd hate to lead you down the wrong path or get you to accidentally make the make the judge annoyed. Oh, you're a litigant in person. We do have, so we don't represent people, we help people represent themselves. And so we do have a 3-hour coaching package, which is where you can basically just get 3 hours with a lawyer who can coach you through some of these very specific things. And so preparing for your final hearing, adding in any new evidence, things like that, that is the sort of stuff you can discuss with them. I will say that it is doable, at least in theory, because I often hear about employers doing this, adding evidence at the last minute, often as a tactic. So, but I can't give you the very specifics because I'm not one of the litigators. However, our coaches are. So if you are interested in that, if you go to vala.uk, you will see on our menu coaching services, and I would suggest the 3-hour coaching package. Okay, so Puggle says, we have our first hearing scheduled for 23rd August, it's my birthday, and the company are pushing to settle. Not surprised, that's a good sign. Not overly happy with the offer, but I'm happy if we'll, I'm unsure if we'll get much more. So Puggle, what is the offer based on? So have you gone through, have you worked with us to put together a list of the potential claims? Well, you will have done the claims for your ET1 if your first hearing is scheduled for the 23rd of August. Like, how have you kind of priced your claims? What do you think is, like, are they working with how you've priced the claims with the settlement? I will say you don't have to settle at all. And as the hearing approaches, they're going to get more and more testy about their legal bills because they will have to pay the legal bills if they have representation for the actual hearing. Whereas if you're self-representing, you don't have that additional cost. And that's one of the ways that employers tend to think about settlements is, let's just get this done so that I don't have to pay the legal bills. So I've been using your platform. Fantastic. Okay, so yeah, I think if you're not in desperate need to settle, please don't feel the pressure to settle. You can always renegotiate or try to renegotiate after the hearing. Once you get a bit of, they haven't really budged, but have offered about 4 months salary plus payments in lieu of notice. Okay, so depending on the type of claims that you have, that could be really fair, or it might, that sounds like it could be fair, but then if you are going for, let's say, a discrimination claim and there's potential injury to feelings involved or things like that, then that could be quite different. Puggle, I don't know if you have seen from my, on our website, on the webinars section, there is a free webinar called How to Settle. That's about the instruments of settling, but we do talk a little bit in that webinar as well about how to think about pricing a settlement. So it might be worth looking at that as well. Okay, so can you stay in a tribunal hearing whilst waiting for reports, which will go towards evidence? Short answer is yes. So you can certainly say, you know, this process is going along at the same time, and so I, you know, might need to enter this into the evidence later on, and just letting the judge know that that is likely to happen. Then the judge can instruct you about how you would do that. Let's see. So much happens between submitting your claim and getting to tribunal. Yes, so much time. How long does a judgment take? It can take a while. I know of people who had a hearing and then they're waiting for the judgment to come through, and they could wait months. Yeah, I wish I could tell you a shorter number, but I think it's a long time. My son is being forced out of his job due to his autism. I'm so sorry, Tasha. And they have put him on a stage 2 disciplinary. Next stage is stage 3 dismissing. OT advised them to do a medical redeployment, but they are refusing. Okay, so Tasha, the important thing to remember here is that whilst there is a narrow set of circumstances where it is legal to dismiss someone because of a medical condition like autism, the employer would really have to prove that there was no other option available. And so it sounds like they're moving through stages, but the question is, just because you tick the box doesn't mean that they necessarily tried in good faith to really work with him. They're saying poor performance. Well, that's fine, but have they has your son requested reasonable adjustments? Have they met or tried to meet those reasonable adjustments before trying to work through on a poor capability justification? And based on what you're saying here as well, I'm assuming that he's worked at the company for over 2 years. No, they just want him out. Okay, then that's probably not very legal. So if you have autism or any other disability, cognitive disability, physical disability, anything like that, your employer, he works at the NHS, and I'm not surprised. We hear a lot from people who work with the NHS. Your employer can only dismiss you after you've worked at a company for 2 years for there's only a few fair reasons that they can dismiss you for, and they also have to follow a fair process. On top of that, if he has a disability, then they also have to put into place or show that there's no reasonable reason to put into place reasonable adjustments. Sorry, that was confusing, but reasonable adjustments are something that they should be working very hard to support. And if they don't work very hard to support it, that is very likely a violation of the Equality Act. If you look at, they're telling him every day that it's his best interest to look for another job elsewhere. I mean, this also sounds like it could potentially trigger a constructive dismissal claim, which is another thing that you would have rights to over 2 years. Mummy Tasha, if you have no money at all, the thing that I would suggest you do is go to my profile and download the ebook and start there. If you have £150, I would suggest that you go straight to our website and buy the Merits Assessment Service. That's where you will upload some materials about your son's situation. One of our coaches will review all of that. Then they will have an hour-long call with you and your son, if appropriate. They will then give you an idea of what they think might be legal or illegal about this situation, what your potential claims in tribunal could be, and how much they may be worth. If you were to win at tribunal, if they think you have some potential claims. Based on everything you've told me, I definitely think at minimum, read the ebook. But I mean, honestly, there's a lot of bad things sounding from what you're saying to me here. So I would definitely check that out. And you can see, oh, thank you, Sushi. And you can see what other people are saying in the comments as well, like Leanne. It definitely sounds like there's some really dodgy stuff going on. Okay, so Arthur on YouTube says, hey there, does access to facilities extend to equipment or software that other colleagues in the same position have access to? Good question, Arthur. I don't know. When you say access to facilities, do you mean as part of a reasonable adjustments request, as part of your contract? That sounds like a specific phrase, access to facilities. Where is that coming from, so I can help better signpost you? Okay, Sutton on YouTube says, my employer refused my right to be accompanied on 2 occasions. Dearie me. They only allowed me to be accompanied by my union rep on my appeal meeting. Have they breached my legal rights? Sutton, what they likely have done is that they have not followed the ACAS code of practice. Now, the ACAS code of practice is, you can't take your employer to tribunal for violating the ACAS code of practice. However, if you do take your employer to tribunal for something else and win, if you can then show that they violated the ACAS code of practice, then you could be awarded up to 25% more of whatever it was that you were going to get anyway because of that violation. So what I would Google is ACAS code of practice violation and Google ACAS uplift. And that will give you an idea of how the ACAS code of practice is typically enforced. So Tariq, hey, what will happen if the other side doesn't disclose documents? I've uncovered a lot of documents via SAR, which I'm waiting for the tribunal to look at this and can't do my statement. Great question, Tariq. So if you have documents and you know that the other side isn't putting them in disclosure and you know that they exist, if they're not playing ball, first you try and get them to include them in the bundle. But if they don't, the next step that you can take is that you can make an application to the tribunal called an application for specific disclosure. Now we have this as a template on our website. I think it's like, I don't know, £20, £10. But you can go to the tribunal and basically say, I think that they're not disclosing something that I think is material to this case, and I would like you to ask them to do it. So that's the kind of mechanism that you can use. What I would also recommend that you do is look, if you Google Employment Tribunal Rules of Procedure 2013, Employment Tribunal Rules of Procedure 2013, that is the rule book for the tribunal. And that will have application for this specific disclosure and other things in it as the different things that you can do when the other side breaks the rules. Okay, let me just keep going here. It looks like some people are supporting each other. I love when that happens. Thank you so much. How much time do you need to finalize a settlement? Employer says if I settle, then the employment ends on the 31st July, but that's Wednesday and not long. How do I make a decision in such an informed short turnaround? Great question, Puggle. So first of all, putting deadlines on settlement offers is a very common tactic that employers will use. And often they put very short deadlines on in the hope that maybe, you don't go and get legal advice, or you don't go and take a lot of time thinking about it. And maybe you just think, oh, maybe I should just do this. I don't know where you are, and Nargis has a great point here. I don't know if you've started ACAS early conciliation. If you haven't started ACAS early conciliation, be 100% sure that you are still within the 3-month minus 1 day deadline from the original act occurring, so that you can still take this to tribunal. But I think in your case, you've already done that. Sorry, I'm just remembering. You've already done that. You're waiting for a preliminary hearing. Perfect. So okay, yes. So Puggle, sorry, Puggle. I'm getting all getting all confused. So in your case, there are 2 legal ways in any kind of settlement to settle, right? There is using ACAS's COT 3, which you can still do far after conciliation finishes. You and your employer could go back to ACAS right now and say, we've reached an agreement. We would like you to codify it via a COT 3. And that's one way to make it legal. The other way to make it legal is if you don't use ACAS, you need to have a solicitor to review the agreement and give you official legal advice. And often the employer pays towards this, usually about £500 or something like that. Either way, they can make you an offer and give you a deadline, but that's usually just a pressure tactic. So what I would suggest that you do is go back to them and say, thank you for the offer. I need to take legal advice. It will take more time than Wednesday. Let's get through the preliminary hearing and I will get back with you if you do not want to take the offer at that point. Or if you do want to take the offer, but you don't want your employment to finish that quickly, then you can negotiate on that. These are all negotiations, and it often feels like you don't have any space to negotiate, but often you very much do. It's just that employers try and make you feel like you don't really have any kind of say in this. And if you do want some support in understanding how to price, and this isn't just for you, Puggle, because I think you're already working on the platform, but if you do want some support to price a settlement amount, our merits assessment service that I just described earlier is designed specifically for people who are in that kind of before preliminary hearing. So anywhere between after a grievance or a disciplinary and before the PH, when all of that negotiation's happening, and they want to see if they whether or not they should take it forward and make the tribunal claim and take it forward, or if they would like to settle, how much they could settle for. Sorry, that was a very long answer. Work anniversary in August, so I think I'd be entitled to more after. Good question, Puggle. So, one thing I don't know is if if you've worked at a company, actually, it doesn't matter. If you've not been dismissed, if you've not been dismissed, the 2-year mark still applies if they dismiss you after 2 years. Constructive dismissal is another one of those claims. 8 years. Okay, then you're absolutely fine. Okay, let's look at some more answers. Oh, loads of questions or loads of comments on YouTube. Hello, YouTubers. Dree says, thank you so much to the entire team at Vala. Oh, thank you. My case has finally been resolved. Thanks to all of your enlightenment and being able to put my case forward structured and informed in a clear way. Oh my goodness, thank you so much for that. you've actually kind of perfectly kind of captured what we try to do. I don't know if you'd be at all willing to do a review on Trustpilot, but even if you just pasted that into Trustpilot, I would massively appreciate that, because that is exactly what we're trying to do. Help you put your case forward in a structured and clear way so that you get taken seriously. So huge well done, and thank you. Arthur says, basically, I didn't have access to software needed to carry out my role and requested multiple times for access to be given, but kept on being denied whilst colleagues were given access. Okay, so Arthur, I think I need a few more pieces of information. So was this part of, for example, like a punishment campaign because you had spoken up about something that was illegal at work? So could it be part of a whistleblowing claim? Was this part of them trying to push you out of the company and you'd worked there for over 2 years? So it could potentially be part of a constructive dismissal claim. Is this part of behavior that is happening to you because you have a particular protected characteristic? Therefore, it could be part of a harassment claim. So often what I do on these calls and these lives is I'm helping people try and take what has happened to them and match it to the available claims that you can make in tribunal, so that you can then see if you have legal leverage. I'm not aware of any specific legislation that says you have to give the same level of software or any kind of access to different employees. There could be a potential breach of contract element to that, but I'm not au fait in that particular area of employment law, so I wouldn't be able to help there. But those other avenues are possible. The other thing that I would suggest you do, Arthur, is if you go to our website, hi Mevi, if you go to our website and vala.uk and look for our bullying guide, it's like the 5 steps to dealing with bullying. I go through in that guide all the major different ways that bullying can be illegal. And it sounds like there could be a bullying aspect to your situation. Bullying itself is not illegal, but there are many kinds of bullying that can be illegal depending on the circumstances, like some of those that I explained to you. And in the article, I try and give you a lot of examples of different ways that bullying could be illegal. Right, let's see. Okay, Mirwani. Hi there. I recommend having a purchase template from Vala and the coaching for peace of mind. Very good for checking the grammar. I'm so pleased to hear that, Mirwani. Thank you so much for the vote of confidence. Sutton says, my employer's solicitor has offered an early settlement. I'm not sure if this is because of the cost of the solicitors or if I have a decent case. The employer, I doubt the money is the issue. So in a lot of cases, it is down to the solicitor's fees. Or they just don't want to kind of have to deal with the time and disruption of actually preparing for a hearing and all that kind of stuff. So sometimes it's because you have a super strong case. Sometimes it's because that's their policy and they just decide to settle so that they don't spend time on solicitors' things. It really depends on the employer and what kind of tack they take to it. I think the real question is, why are you raising the claim in the first place? What is your ideal outcome here? Remember, employment tribunal cannot get you an apology. It can't mandate that the employer goes back and changes its policies. It can't mandate that other people get treated more fairly after you, although those are often the reasons why people might start going through this process. It can give you accountability and a third party to say whether or not what happened to you was illegal, and it can give you compensation. So those are, I would think through, what do you want here, and kind of take it from there. Okay. Oh my goodness, so many so many questions. Let's keep going. Z, I have a case against ambulance service, which I have just submitted my ET1 form, and I just found Vala. I had written a grievance letter that is 62 pages long. Before sending this, would the Vala merit assessment cover a document this long? I've adapted a no stone unturned approach to outlining every possible legal and ACAS breach, only just become the process. So Z, we actually use technology to review the documents that you upload. And so, yes, we would, the coach would not read your 62-page document, but the technology that we have developed would read the 62-page document and would create an automatic timeline for the coach of what the most important points are, and then summarize the document, and then also try and surface to the coach the most what it thinks that the most relevant legal claims could be, or the claims that you have discussed. And on top of that, we'll do that with any other document that you have. The coach will then be able to read through the documents, glance through them, but for 62 pages with the cost of that service, they wouldn't read all 62 pages, but they would get the highlights, and then they would start digging into some specifics with you. And so that's how that particular merit assessment kind of functionality works, if that makes sense. A lot of what we do is with that merit assessment is we're trying our best to find that balance between affordable, quality, and human touch, because what we've learned working in this company for years now is that we can't really help someone with a legal issue unless we fulfill 3 pillars of support. There's the organizational support, even just helping you sort through all these documents, these timelines, etc. There is the legal support, giving you that legal advice. And then there's also the emotional support of all of this. And so when we are designing services like our merits assessment, we're trying to balance cost against those 3 pillars to find a solution that kind of helps everybody, helps as many people as possible for the price that we can offer it at. That was a long-winded answer. I hope that's useful. Very pleased that you've had the videos are working or being helpful as well. Okay, so let's go back to TikTok questions. Let's see, what have we got here? How does shared parental leave work? I'm afraid I don't know, user 526. I'm so sorry. I think there are some really good HR experts here on TikTok, but I don't typically get involved in the non-sharp ends of HR problems, if that makes sense. Right, let me see. I've been approved for obtaining information at the county court. What is an affidavit? Maybe that's a good question. An affidavit, I believe, is just a statement that has been confirmed legally. But I don't actually know. Are you taking a... What's the case that you're pulling together? I'm not a county court expert. We're actually just looking into this for a second area of law, but this isn't my area, so I probably can't help, but I am curious and will help with anything that I can. Candy Girl, good to see you. Discrimination. Is harassment relating to a protected characteristic also considered? Okay, so Candy Girl's pointing out, Citizens Advice says that you can claim constructive dismissal under 2 years if it relates to discrimination. Is harassment relating to a protected characteristic also considered constructive dismissal? No. Although Citizens Advice is correct. If you are being bullied out of your job, there are a couple different ways that might be illegal, both depending on the circumstances and depending on how long you've worked at the employer. If you're being good to see you too, Candy Girl. If you're being bullied out of your job and you've worked at the company for over 2 years, the reason why you're being bullied out of your job doesn't matter, because you have the right to not be constructively dismissed for any reason. If it's under 2 years and that protection isn't there, then the reason you're being bullied out of your job can matter, because that can make it illegal anyway. And one of the reasons might be because you've blown the whistle about a public safety issue, a fraudulent activity, etc. Bullying you out of your job for that reason would be considered a detriment of whistleblowing. It could be because you've spoken up about a discrimination issue and you're being punished. That would be a victimization issue. Or it could be you're being bullied out of your job because you have a protected characteristic and they're creating a hostile, degrading, humiliating environment for you, in which case that would be harassment in the Equality Act. So this is why that article that I've written on bullying, which I believe is in my profile, if anyone wants to click on it there, is so important, because I try to go through, here are all the different ways that bullying could be illegal, so that you can then play the matchup game with your, it's like the shittiest matchup game ever, with your situation, to see if you can find if a relevant claim applies, which then gives you that legal leverage, which then means you can go back to your employer and either say, look, this is not okay, sort it out, or I will take you to tribunal, or I'd like to negotiate a settlement to leave, etc. What does this mean? Straight up, let me see if I missed an earlier question. What does what mean straight up? Okay, so let's see. Let me see, I'm gonna keep going. Loads of great questions. I forgot what time I started. How long have I been here? I don't even remember. Oh, half an hour. Okay, cool. Right, here we go. Does it affect your case if you haven't lost your job through discrimination? Sometimes, Kaylee, it depends on how long you've worked at the company. If you've worked at the company for over 2 years and you've been bullied out of your job, then that could be constructive dismissal, or it could be unfair dismissal based on the circumstances. If it's under 2 years, there are other areas that would constitute a automatic unfair dismissal other than discrimination. For example, whistleblowing, trying to organize a trade union, trying to use part-time workers' rights, things like that. But a lot of them are also related to discrimination. Now, Sue, I can never pronounce your name. It's the beautiful French name, asked, how can I become a Vala coach? Great question. So I think we're still recruiting right now for more Vala coaches. And if you go to our LinkedIn page, just Vala on LinkedIn, you'll see the job advertisement. I think it's still live. If not, just email us at hello@vala.uk. We're specifically looking for people who have experience in the tribunal at the moment, who have helped litigate cases. We are then going to be, we'll introduce more kind of training later on, but for now we're, I don't know your circumstances, but we're specifically looking for people who, often they come from either a solicitor background or an HR background, or sometimes they've worked in charities supporting litigants or representing litigants. But basically that tribunal experience is the key thing that we're looking for. Do larger companies such as banks try to settle early, or are there no general patterns? James, it really, really depends on the company. Some companies that I've talked to said that they always just settle straight out of the gate so they don't have to deal with it, but they go for the smallest number possible. Other ones say we don't settle at all. I would say that the larger the company, the more likely they are to be getting professional HR advice, and HR companies that are kind of outside of the main employer tend to have some playbooks, and that playbook often has a lot of tactics in it that will often encourage people to drop a case. And so, I would say in general, I have seen a trend of people getting professional advice to use a certain set of tactics that can demotivate an employee. But generally, it really depends. A barrister is requesting 25% of the settlement agreement letter to do that. Is that accurate? So, Stushi, good question. Part of it depends. I'll come back to you, Big Mama. Good to see you. Part of it depends on how much the amount is. So, if you think about a typical hourly rate for a barrister, how many hours, the way that they're probably thinking about this is, how much do I think it's going to settle for? How many hours is this going to take me? And then what is the hourly rate that this would be the equivalent of? Okay, it's 25% of this case, so that's what I will ask for. That's probably how they're doing that maths. The Burger Man Van, I know you. How does that make you feel? It makes me feel like I'm going to block you. 1 second. Creepy. Okay. So yeah, so a region of 100,000. Okay, in that case, barristers, I think, are typically about £400 or £500 an hour or something like that. So depending on how much time they're helping you with, maybe. You could also, if you've got something in that size, I would definitely feel free to shop around and talk to a few other people as well, because that is well over the amount that a no-win, no-fee firm would be really keen to take the case on for you. And so I think you could definitely, just to do the letter. Yeah. So what, if it doesn't settle, would they still want 25% just for the letter and no other support afterwards? Or would it be to get you through to the settlement and contingent on the settlement actually being successful? Okay, and tribunal if needed. I would shop around and see if other people, I don't know what the percentages are these days. So I would definitely shop around and ask a few other people. With the size of case that you're talking about, other people will bid to take your case. Okay, let me see if I can find some more answers. Okay, so Big Mama, I saw you there. My ex-employer won't pay my unused holidays. I have received my P45 already, but no holiday pay. Oh goodness, I'm so sorry, Big Mama. So if this went to, so this is a potential unlawful deduction of wages claim. So if you look up unlawful deduction of wages, unpaid holidays would fall under that. It's one of the more straightforward tribunal claims. And as a starting point, I would definitely go back to them and say, I believe that this is an unlawful deduction of wages. Please sort this out for me. And then you could take it from there through ACAS early conciliation, etc. Okay, let's see. Final hearing is in January next year. ACAS asked what I would accept to resolve via conciliation rather than the tribunal hearing. That's a very normal question, straight up. If you think about what is ACAS set up to do, ACAS is set up to try and prevent cases from getting to tribunal. That is their job. They want to help resolve as many situations as they can to prevent them from getting to tribunal. And so their job is to try and get a deal on the table if both sides are willing to negotiate. If that is a good deal, I mean, that's what our merits assessment service is for, to help you figure out, is this a good amount that they're offering to settle for? If you want to know more about that, there's a link in the bio. Or you could use our claim builder and try and work backwards from the different types of claims and what you could ask for. But it's not unusual. It is their job for ACAS to kind of ask and to try to facilitate this. Bella says, my ex-employers tried to scare me off, but I persisted and won. Well done, Bella. Love hearts. Do employers use Vala too? No. No, we don't have a service for employers. Many have asked. I think it's really interesting. I think there is definitely a company out there that can help employers do a better job of managing the grievance process, managing all these sorts of things. But I don't think it supports us. I just don't think that we need to build tools for employers when there's other areas of law outside of employment alone that you all have problems with. I'm much more interested in expanding into tenancy law, for example, rather than expanding into an employer tool. With that said, we're having some really interesting conversations with employers who are trying to figure out how to give their employees they're in a dispute with a better understanding of what the legal claims are around the case. And so they're getting in touch with me and saying, could we actually pay for someone to get a merits assessment so that they have a better idea, and the other so that they have a better idea and they know if they do have a case, because obviously you're not going to trust anything that your employer says about whether or not you do have a case, often because they have abused that privilege, and employers in general are not very honest when it comes to the merits of your own case. So I think there's some interesting ways that we could work with employers, but in general, that's only to better get access to information for employees and consumers in general. That's what Vala is all about. Okay, let's see, goodness. So many great questions. Can you explain the difference between a detriment and retaliation? So Brian, good question. I'm trying to remember. So I can't remember if retaliation is a legal term when it comes to whistleblowing or not. No, whistleblowing is a detriment as well. I'm not aware of retaliation being a legal term in the areas of law that the main claims that I know of. And so if you think about what either of those mean, retaliation in these situations is typically you do something and your employer punishes you for doing it. And typically, my goodness, so many great success stories coming through here. I'm going to come back to both of these. This is so exciting. So if they retaliate against you, in whistleblowing law, that's called a detriment. And if they retaliate against you in victimization law and in the Equality Act, I think it might be, Brian, that is also called a detriment. And so in both cases, the detriment is the punishment. Retaliation, I do think, is a US term for the same thing. So what I would Google is detriment and see if that helps you. Oh, Casey's saying penalization is another term for it in whistleblowing. Okay, great. So I had a few great messages here. Let me just see this. You're very welcome, Arthur. Got a quote from a law firm to represent £60,000 for preparing a 15-day hearing. My goodness, I hope Vala succeeds. Yeah, for a 15-day hearing, I'm not at all surprised that you're getting quoted £60,000. And this is the thing, I mean, you can't, the amount of money you have in the bank has no control over how many days hearings you need, but the amount of money you have in the bank directly controls whether or not you could afford £60,000. And so it's just not an option for so many people. It's outrageous in that there were no other options. Those solicitors do a great job and they absolutely deserve to get paid. It's just that not many people can pay that amount. So somebody said here that your package and website helped me settle a £20,000 win. Tech Bear, I am so delighted to hear that. And I remember you, Tech Bear, and your fantastic feedback on the website as well. I asked somebody else earlier if you would be willing to give us a review on Trustpilot. I would just love that so much. This is the kind of story that we copy and paste these and do screenshots, and then we put them into our Slack channel for the team as well, just so we can see, that what we're doing is really making a difference. God, I'm so delighted for you. Well done, Tech Bear. Okay, great. So Casey, for Brian, who was asking about this, Casey has quoted you a bit of legislation over on YouTube. I'm just going to see if I can copy it. Oh, I can't copy it for some reason. It's section 146 of the Trade Union. I don't know what that means. TULRCA. That's the acronym for the law. TULRCA, section 146. I can write down section 146 TULRCA. Look into that for penalization, Brian. Okay, wonderful. Let's see, what else have we got here? What if my employer won't approve my flexibility request after coming back from my mat leave? So Eliza, I did a video on TikTok. If you look for flexible working, or maybe, I can't remember the name of it, but I did a video specifically talking about a case where someone successfully, flexible working law is not very strong. Basically, your employer has to show that they really did consider it and that they have a reason to say no. But if they do prove those two things, then they can say no. However, if they always knew that they were going to say no, then that could be a violation already. Or there's also a lot of people who pair up their flexible working requests alongside a potential sex discrimination claim, because often women in particular, and this is recognized by the courts, take on the brunt of child rearing and childcare responsibilities. And so if, for example, they said, we don't do any flexible working as a company, that's very likely a potential discrimination case on the basis of sex. So I would definitely go back and look in some of my older videos, because I know I specifically covered a case like this in TikTok. It'll be on my YouTube channel as well. And you could also, if you really want to dig into this and get a legal opinion on it, that's what our merits assessment service is for. Before doing that, I would recommend as well that you go to my profile and download the ebook, which is also free, which will give you a better idea of what's going on. It's the Trade Unions Labor Relations Consolidation Act 1992. That's what the TULCA is. Thank you so much, Casey. And detriment, which is in the Employment Rights Act, detriment for protected disclosure, and protected disclosure is relating to whistleblowing. So those are all examples of retaliation, but the legal term isn't retaliation. The legal term is either penalization or detriment. And detriment is the one that I most commonly see here in the UK. Right. What have we got here? Let's see. My mum represented me. Oh my goodness, Bella. My mum represented me using Vala's advice and templates. I won on reasonable adjustments. Thank you, Vala. Oh my goodness. I'm going to take a screenshot so I can show the team. They're going to love this. I'm so pleased to hear that, Bella. A huge well done to you and your mum. Can we all just give Bella and Tech Bear, and I think somebody else talked about a win as well. Can we all just give them massive like hearts and claps, because it is so hard. Like, this is so hard. For those of you who don't know, we do a employment tribunal support group every month, and we get hundreds of signups every month, literally just because this is so hard and it's so stressful and you often feel completely alone in it. And so we get together on a big webinar and we all just say hi to each other and support each other, just like you're doing in these comments now. And, you know, I am so in awe of the strength of all of you to stand up against these things and to say, you know what, I think I want this to stop with my situation and I want to hold them accountable for what happened. And I like to do that is incredible. Like, and so well done. Well done. Andrew says, I submitted the subject access disclosure to my employer. They refused to search employer issued devices for instant messages and said that it was too onerous for them to search. Over 2,000 employees. Okay, so Andrew, there's two things about this. One is, I would suggest that you scope your subject access request to specific people or specific teams wherever possible. And if you use, we have a free subject access request template with a video course embedded inside of it. If you go to vala.uk and you create a free account, you'll see it in the template section. And we specifically talk about how to scope down a subject access request so that they're less likely to be refused for these kinds of reasons. The other one is, actually, employer issued devices. So often an employer can say no to personal devices. So for example, like WhatsApp messages or things like that. But employer issued, they absolutely shouldn't be able to say no to. And even in the case of personal devices, if your employer expects you to use that personal device as part of your work, so say, for example, you work at a restaurant and all of your scheduling happens via WhatsApp, then that should be within the remit of a data subject access request. So Andrew, I think in this particular case, I would go back to them and scope your request down and say, okay, well, if you can't search all 2,000 employees, fine. But I would like you to search the people within these teams, or even better, I would like you to search these particular named individuals. Okay, they did. Okay, so Andrew has already followed all of the advice that I gave. Well done. And Andrew, you are so on it. Andrew is on it like a car bonnet. They still refused. I've now applied to the court for a specific disclosure order. That is exactly the right thing to do next. And I would go ahead, just for fun, go ahead and submit your complaint to the ICO as well. And the fact that you made it specific and they're claiming that it's too onerous definitely can help with an ICO claim. I don't see the ICO enforcing things, but I do think it just helps to put up the heat and also helps your employer to know that you actually are paying attention and that you do care about these things. But well done. My next suggestion was going to be the specific disclosure request. So you are on it. Like, oh, sorry. I get all excited because I just love seeing people knowing the rules, knowing the rule book, and able to use the rule book rather than employers just relying on all of us not really knowing what's going on. Okay, I'm so sorry, user 526. I can't explain share parental leave because I don't have expertise in that area. Can you have a case in the tribunal if the manager said to your colleagues not to be witnesses because they will be dragged down as well while one of their colleagues is investigated? So good question too, Magic Emeralds. I think the key thing here is, and for those of you who have watched me before, you will know what I'm going to say here. You do not have to have a witness in order to have evidence. Your account of what has happened to you counts as evidence. And what you want to use is something called contemporaneous notes. So when I say contemporaneous notes, I mean you go into a meeting, you come out of the meeting, and you write down the who, what, where, when. Who was there? What did they say? Where were you? Was it meeting room 3? Was it the kitchen? Was it a Zoom call? And write down everything that you remember. it's not too late to write down, if you haven't already, what you remember from the situation that you're describing. Sorry for the siren. I've got my window open because it's summer. So just because you don't have a witness, most cases don't have a witness. It's just the claimant is the only witness. But anything that you can do to show that that meeting actually happened, say screenshots from your calendar, the scribbled notes that you took during the meeting, the notes that you wrote down afterwards, all that kind of stuff counts. And if you search my TikTok profile for contemporaneous evidence, you will see a video that talks a little bit more about this. Evidence is king at Employment Tribunal. Absolutely agree, user 526. The other thing I think is so important that people often don't know is that you're not in a court, a criminal court, so you don't have to prove things beyond reasonable doubt. The burden of proof, the weight of proof in Employment Tribunal is called something called, on the balance of probability, which basically means, does the judge think it's 51% likely that you're telling the truth? Not beyond all reasonable doubt, like you would expect in like an American criminal court or something like that. So the things that come into that is, are you being credible? Do you have notes? Are you organized? Are you polite? Are you answering questions well? Do you have a consistent memory of what has happened and what was said? Those things all go towards that evidence of your notes being credible. So that's super important. You do not have to have a witness. And there are ways to make your own account even stronger in terms of the strength and the weight of that witness testimony. Let's see. Would taking my case to a tribunal have a greater likelihood of causing change to the ambulance services policies compared to accepting a small settlement offer? I ask this because they have policies which disproportionately affect Muslims, and I don't want other Muslims to be affected. So first of all, Z, I'm so sorry that you're having to deal with that. That's really, really shitty. I don't think... So you can't guarantee that either one will have an impact on their policies. And as I said earlier, you're very welcome to Magic Emeralds. Oh, sorry. I'll come back to you. The tribunal can't order the ambulance service, for example, in this case, to change their policies. That's not within their remit. They can really only order them to give you compensation. With that said, if you're making a case public, which is what you're doing when you take it to tribunal, then you are putting more pressure on an employer to say, look, I'm exposing these practices which I believe are illegal. And I think that does give some extra weight. Also, if you win your case and the press thinks it's particularly interesting, you then often have an opportunity to speak to the press about that and to kind of make your case there. And if anybody does win a case and they want to speak to the press, we offer this as a service where we can give you some media support for that. We basically, anybody that we've helped win, we want to shout from the rooftops just as much as you do, if that's something you want to do. So just get in touch with us by email and we can help you with that. So Z, the short answer is you can't guarantee it, but I do think probably the more public option is probably the one that creates the more pressure, if that makes sense. Right. AKA, hello. I have been following your advice and notes to help me as a litigant in person against an employer. Now I'm using a specific disclosure order. Amazing. Oh, the respondent is unable to comply, so I filed a non-compliance order and strike out. Well, I cannot wait to see what the tribunal says. And I'm hoping that it sounds like the employer is not following along, is not playing nice. So hopefully that will make a difference. Okay, let's see. And people are talking about different employers not following regulations. I mean, this is why holding to account makes such a difference. If things do not go, if there are not consequences for actions, then behavior will never change. And that's one of the reasons why I often call Vala an accountability machine. If you think fundamentally, what are we building? We are building an accountability machine for society because we are opening up the ability for more people to hold people accountable for unlawful behavior. And I think we've gone far too long where people were just completely priced out or blocked out of holding people accountable, powerful people. And so, like, yeah, sorry, I won't get on my soapbox. How do I go about raising a constructive dismissal claim? My employers have become toxic towards our team. Natsa, I'm so sorry to hear that. If you've worked at the company for over 2 years, constructive dismissal is definitely an option. It is a tough claim to prove, and the first thing you'd have to do to properly raise a claim, not just say that you're going to raise that claim, is to actually resign. I would suggest that you have a look at the free ebook that's on my profile. I would start there, and that just lays out the whole process of how to raise a particular complaint, find your legal leverage, etc. Marco, so sorry, I missed your question. Oh, the application for Rule 21, a template. Yes, we can actually help you with that. So we don't have the template available right now, but we can still help you with that. If you get in touch, Marco, if you email hello@vala.uk and say, I see that this template isn't available. I was wondering if you could help me with this anyway. Jade or Bemi will be able to get back in touch with you, and hopefully we can still support you with this, just not with a template that is filled out on the website, if that helps. Probably with like a bit of coaching, and a coach can help you work through that. Any experience removing yourself from work due to stress by Section 44 of the Employment Rights Act? Good question, Gaines. And no, I do not have experience with that, but I'm going to look into that and ask around in terms of our coaches. And if I do find some stuff about it and some tips for it, I will make a video. Section 44, stress. Sorry, I don't have an answer now, but thank you for putting me onto that. Okay, so I've got about 5 minutes left. Okay, I bought from you the ET1, but the employer still didn't answer. Yeah, definitely get in touch. Oh, for health and safety. Yeah, so I'm not an expert on health and safety, but the coaches will know about it. And in fact, if you do want, what I would suggest, Gaines, is if you do want to speak to somebody about it, I would email in hello@vala.uk and say, I think it would be a merits assessment, and say, are any of your coaches particularly experienced in this area? And if so, we can then set up a merits assessment specifically with that coach so that you can speak with them and they can have a look at your situation and give you some specialist support there. So definitely just drop us an email and we can help with that. And that's in general what I would suggest that you do. We have a wonderful team on hello@vala.uk. Your content and tools. Oh, thank you, Gaines. There is one person who looks at our TikTok messages. There is a whole team that looks at our hello inbox. So if you do want to get some personalized signposting about, what should I do next? What could you do to help me? All that kind of stuff. Email hello@vala.uk, and Jade and Bemi are wonderful. Could I apply to strike out the respondent's defense even though the tribunal date is next February? You could, Reg, and often an employer will do that straight out of the gate. Just at they'll often submit a strikeout application alongside their ET3 grounds of refusal. There are two different things that you can. So a strikeout, basically, and this is why I would recommend that everyone read the Employment Tribunal Rules of Procedure 2013 if you're kind of thinking about using some of these tactics, because they kind of list the rules of the thing. So a strikeout is basically if you think that the employer has no reasonable prospect of success. If you think, and that's one bar. The other bar is if you think they have little reasonable prospect of success. And so what you're actually asking the judge to do in either of those situations is to look at the information that they have so far, which will be the ET1 and the ET3, and to say, I don't actually think that this employer has a leg to stand on. So if they don't have a leg to stand on, then they might grant you your strikeout. Or if they think that they've got a really shaky case, that would be an application for a deposit order. And so that's like the softer version of a strikeout with a lower bar. And so in that case, the judge would say, I'm not seeing a lot of good stuff here, employer. You need to pay £1,000 in order for me to not just throw this whole thing out. So kind of put up that this isn't vexatious. So a deposit order is one or the other side has to pay £1,000 to keep going with the case. And so strikeout and deposit orders can be paid on both sides. So an employer could ask for a deposit order against you. You can ask for a deposit order against the employer. And in both cases, you basically need to prove that basically need the judge to rule that there is little reasonable chance of success, and a strikeout is no reasonable chance of success. Okay. Right, I am going to go now because I just got a notification that I have a meeting and I just kind of got carried away here. So I'm going to go. So I'm sorry that I need to go just now, but just a quick sum up. If you have any follow-up questions, email hello@vala.uk. The free ebook that's in my profile is absolutely, that is where I'm, oh, thank you, Jay. That is where I really try and lay out for you, how do I get leverage in this situation, right? When is the next live? Good question, Kay. I don't actually know. I will try and do one on Wednesday afternoon at 4 p.m. I'll put that in my diary. That's my usual slot. So I will try and do a Wednesday at 4. Also, if you go to our website, Kay, vala.uk, and you sign up for our newsletter, we do monthly employment tribunal support groups as well, where we can try and answer questions and help you out. All right. Thank you all so much. Have a wonderful day. I'm sorry I couldn't stay longer. And look at all of you supporting each other as well. You're amazing. Huge well done. And I will see you all again soon. Thank you. Bye-bye.